Welcome to the Workforce Guardian Workplace Relations News Bulletin for the 20th of September 2018. My name's Charles Watson. I'm the General Manager of the HR and Consulting Advisory Team for Workforce Guardian. Today we're going to cover a few issues of relevance to your business. We start with an update on an accounting firm's accessorial liability. After being prosecuted at the initiative of the Fair Work Ombudsman last year, Easy Accounting 123 were fined over $50,000 when the federal court determined that the firm had facilitated underpayments to several employees of one of their clients. The accounting firm provided payroll services, processed wages for a client, despite knowing that the rates the workers were being paid were below lawful award minimums. Now, Easy Accounting appealed that decision, and they attempted to argue that there was no basis for the original finding that they'd contravened the Fair Work Act. However, the full bench of the federal court disagreed and found that the principal of the accounting firm had enough knowledge of the relevant award, including that it required the payment of a base rate as well as penalty rates. Further, the situation was exacerbated by unreliable witness evidence given by that principal at the original hearing. The court upheld the original decision and found that the outcome wasn't surprising, given the acceptance by the accounting firm that the amounts paid to the workers were less than the base rate of pay, which led to the inevitable underpayments. So if you're an advisor to a business on these related issues and you have concerns, you need to clearly articulate those concerns and be prepared to walk away from your client to avoid possible accessorial liability. You can't and you can no longer point the finger at your clients as an excuse anymore. Therefore, it's quite clear that you need to keep up to date with your obligations. You need to raise concerns as you come across them, and you need to fix underpayment related problems when they're discovered. Move on to the recent decision of the federal court relating to casual employees. It's resulted in a level of concern for employers, particularly after the usual suspects in our field have started with the "we'll all be ruined" behaviour. So when casuals aren't casuals? Historically speaking, there's a range of common law indicators that have been applied in the past to determine whether an employment relationship was one of casual nature or something else. Factors such as the irregularity of employment, the uncertainty of ongoing engagement due to the haphazard nature of available work could all evidence that the relationship was not one of permanency. With those indicators came the requirement that employers pay such casual employees a premium on that rate of pay. It's now a standard 25% of the base rate of pay, and such a casual loading was implemented to effectively dissuade widespread use of casual labour, and was also effectively compensation for the foregoing of annual leave, personal leave, notice of termination, redundancy pay, and the uncertainty of ongoing employment. Now, in more recent times, and in the absence of a clear definition of casual employee within the Fair Work Act, many employers have become comfortable operating on the definition found in most modern awards, and that is that a casual employee is one engaged and paid as such. But this doesn't take into account or consider the common law indicators that are still influential. So employers have on occasions mischaracterised employees as casuals when the relationship was far more serious and ongoing. A recent federal court decision is one example of such mischaracterisation. In the WorkPack decision, the court found that a labour hire employee engaged as a casual and supplied to work as a dump truck operator at a mine wasn't a casual, and that was because his employment was regular, it was predictable, his shifts were organised 12 months in advance, his employment was continuous, and it was in fact facilitated through a FIFO arrangement, and also the provision of accommodation at no cost to the employee. And that in itself was inconsistent with the notion that the employee could elect to work on any day and not work on other days without first making sort of necessary arrangements. Additionally, there was a clear expectation that the particular employee would be available on an ongoing basis. It doesn't appear that the decision was appealed to the High Court, and we'll see if government intervenes legislatively speaking. But what the WorkPack decision does result in is that employers need to carefully examine the employment patterns of what they're calling or characterising as casual employees, given that this decision of the federal court contemplates the proper category of an employee varying over time as circumstances might change. Therefore, a review needs to be undertaken periodically. So we'd recommend that employers review how casual employees are engaged and how far in advance there's a roster or a stated commitment to work agreed days or hours. Review those contracts of employment to ensure that casual loadings are attributed a clearly identifiable amount and not just expressed as and casual loading. And it should be expressed to be able to set off with an identifiable value for annual and personal leave that would otherwise accrue. Okay, we move on to family and domestic violence leave is being legislated for all national system employees. As previously predicted, the federal government has sought to legislate the right for all national system employees to access a period of leave when they are experiencing family and or domestic violence. From the 1st of August 2018, as a result of a March decision of the Fair Work Commission, a new clause providing 5 days of unpaid family and domestic leave took effect into the 123 modern industry and occupation awards. The new clause inserted by the Commission, however, only affected employees whose terms and conditions were covered by an award. However, now the federal government has put forward the Fair Work Amendment, Family and Domestic Violence Leave Bill 2018, seeking to amend the Fair Work Act and insert a new entitlement into the National Employment Standards for up to 5 days of unpaid family and domestic violence leave. So if the bill passes into law, the new entitlement to the leave would ensure consistency in entitlements for all employees in the national system. So we await progress of the bill through Parliament, and of course we'll provide further details when that is finalised. Okay, our next subject for today, illegal phoenixing. Illegal phoenixing activity generally involves company directors who deliberately try to avoid paying company creditors. Directors might transfer company assets to another company with the same or similar name and for no value before handing the original company over to an external administrator. It's deliberate and seeks to exploit the limited liability of the corporate form, if you will. Now, phoenixing activities have a very clear detrimental impact on our economy, and they have a very real detrimental effect on small business suppliers who are often left high and dry by such behaviour. Additionally, government revenues impacted when phoenixing companies don't pay tax debts, and employees can lose entitlements when phoenixing activity occurs, and often they won't be paid superannuation as a result. Now, as part of their promise to stamp down harder on this corporate behaviour, the federal government's put forward draft legislation for public consultation. The current proposals include reforms that will create new criminal and civil Phoenix-related offences. They're going to target pre-insolvency advisors and facilitators of such illegal activity. Again, we see an increase in the accessorial liability provisions. ASIC would also receive a new regulatory ability to recover property. The new laws would prevent directors from backdating their resignations to avoid personal liability, and that also make directors personally liable for GST liabilities as part of extending director penalty provisions. So the proposed reforms follow extensive public consultation. The proposed reforms are, in some respects, one step closer to where the law should be, which is good news for the business community generally. So while some directors and company owners may not care one iota as to what the phrase good governance or integrity means, there'll be a need for government to step in whilst that occurs. Hopefully the final legislative outcome will be well drafted and target those who misuse the corporate form. But also, we hope that it will minimise any unintended impacts on legitimate businesses and legitimate restructuring within those businesses. Casual conversion. So last year, the Fair Work Commission ruled that modern awards will have a casual conversion clause interleaved if they didn't have one already. The model clause was settled and will be effective from the 1st of August this year, and it will relevantly form a term of most modern awards, if they didn't have one already, dealing with casual conversion. Effectively, the clause will give award-covered regular casual employees the right to request their status be converted to permanent, part-time or full-time. If that employment pattern would continue without significant adjustment. A regular casual employee, by the way, is defined as one who has worked a pattern of hours on an ongoing basis over 12 months. Now, the expression significant adjustment's a little grey, but we'd say it's best viewed from the perspective that the required adjustment to the casual employee's hours of work meant that the employee is not really a true regular casual employee in the first instance. So that would mean that it is a significant adjustment if they were not truly a regular casual employee. Now, whilst that right goes into the awards, it has to be remembered that casual employees are not required to request conversion to permanent status just because they achieve 12 months of service. But once a regular casual employee achieves 12 months of service, their right to request that conversion remains continually exercisable during their employment. So to comply with the new provision, an employer is required to furnish every casual employee with a copy of the clause within the first 12 months of their engagement. This means that you as an employer would satisfy your obligation by providing a copy of the clause to a new casual employee upon commencement. Then, having discharged your requirement, the onus is then on the employee to write to their employer to request conversion if they meet the definition. Now, an employer has a right to refuse a conversion based on reasonable business-related grounds and after consultation occurs with the employee. Where the employer refuses the request, the reason for refusal or the reasons for refusal have to be given in writing and within 21 days. If your employee doesn't accept the refusal, that could constitute or be enough to constitute an industrial dispute that they might attempt to have resolved under the terms of the award, or take straight and directly to the Fair Work Commission for resolution. So we recommend that employers obtain and review a copy of a relevant conversion clause from each applicable modern award, fulfill any obligations under the award as and when required, and appropriately respond to any employer request for conversion, but also keep copies of any communications and journal any meetings that you hold with employees on the issue, and also ensure the employment contracts are varied appropriately if an employee is converted across to permanent status. Now, to finish off this news bulletin, the fallout from the hashtag #MeToo movement has expanded and expanded into commercial dealings between companies. Let's call it the Weinstein Clause has appeared in US mergers and acquisition related agreements. It's more about financial and liability related butt covering than being virtuous, but it is a thing now, and it may appear in Australia in mergers and acquisitions, and we may see it also move into offers of employment. Essentially, the clause says that, to the knowledge of the company, no allegations of sexual harassment have been made against, an officer or director of the acquired company, directly or indirectly, or that the acquired companies have not entered into any settlement agreement related to allegations of sexual harassment or misconduct by an employee, contractor, director, officer, or other representative. So although it's not specifically workplace relations, a workplace relations term, and is in a sale of business contract in the US, it does provide a basis for a company to contemplate the culture and behaviour of its employees, particularly if you decide at some point in the future to sell that business or that unit of the business, and the sale contract might end up having a clause like that in it. Anyway, that's it for today's update. Please feel free to get in touch with us here at Workforce Guardian if you have any queries or concerns about the issues I've discussed today, or any other HR or workplace relations related issues. Thanks very much, and speak soon.